For decades, America told itself a comforting story, that the era of forced segregation was over, that the hardest battles had been fought, the worst instincts restrained by law, memory, and vigilance. And yet, this week, quietly, almost bureaucratically, another of those guardrails came down. A federal court, at the urging of the U.S. Justice Department, lifted a school desegregation order that had stood since 1967. Not because segregation had been proven impossible to return, but because, as officials put it, there had been no disputes. I want you to pause on that logic, because history teaches us something uncomfortable. Systems don't fail loudly at first. They fail politely. They fail in court filings and joint motions and press releases that sound like closure. If this feels distant, abstract, technical, stay with me. What's happening here is not about one parish or one decree. It's about how a nation decides when protection is no longer necessary. And that question takes us deeper. What makes this moment so consequential is not just the decision itself, but how it's being framed. The Trump administration argues that these desegregation consent decrees have simply outlived their purpose. That if there are no active disputes, no lawsuits, no obvious violations, then federal oversight is unnecessary. On paper, that sounds reasonable. In reality, it misunderstands why these decrees existed in the first place. They were not rewards for good behavior. They were safeguards against relapse. The DeSoto Parish decree was imposed because the federal government concluded more than a decade after Brown versus Board of Education that segregation was still happening. Not accidentally. Systemically, the absence of conflict today does not erase that history. It reflects the very pressure the decree was designed to apply. Remove the pressure, and you remove the constraint. This is not a legal housekeeping matter. It's a philosophical shift in how power views equality, enforcement, and memory. To understand why that matters, we have to step backward into the origins of these decrees and the cycle that created them. To understand that cycle, you have to remember what came after the Supreme Court ruled segregation unconstitutional. Brown v. Board of Education did not end segregation. It declared it illegal. Those are not the same thing. Across the South, school systems delayed, resisted, and quietly redesigned segregation under new names. That is why, more than a decade later, the federal government was still filing lawsuits like the one in DeSoto Parish in 1967. Consent decrees emerged as a blunt but necessary tool. They were not symbolic gestures. They were enforcement mechanisms, ongoing supervision meant to prevent old patterns from reasserting themselves once public attention faded. And that fading mattered, because segregation was never just a policy choice. It was a habit, a structure, a default setting that reappeared whenever oversight weakened. These decrees existed precisely because discrimination adapts. It doesn't announce itself, it waits. That historical reality is what makes the current moment so dangerous. And it sets the stage for the first rupture when dismantling protection begins to masquerade as progress. The first rupture comes wrapped in the language of restoration. Louisiana's Attorney General celebrated the ruling by saying, DeSoto Parish has its school system back. That phrase matters because it implies something was taken. That federal oversight was an intrusion, not a response to proven discrimination. The Justice Department echoed that logic by joining the motion to dismiss a case it once championed. Same institution, opposite mission. And the justification was strikingly thin. For 10 years, we're told, there were no disputes, no conflicts, no complaints. But as Justice Ruth Bader Ginsburg once warned in her dissent in Shelby County, discarding protections because they appear to be working is like throwing away your umbrella in a rainstorm because you are not getting wet. The decree didn't fail. It succeeded, yet success is now being used as evidence that it was never needed. If you care about how power reframes history to justify retreat, this is a moment to pay attention. Because once a safeguard is gone, it's almost never rebuilt in time. And this was not an isolated decision. It was a signal one that points to a deeper, more systematic mechanism at work. What we're seeing here is not randomness. It's a mechanism. Desegregation consent decrees were designed to do one thing above all else: deter. They sat in the background, quiet but consequential, reminding local authorities that federal scrutiny had not disappeared. Remove that presence, and you change behavior without issuing a single new order. The Trump administration didn't need to argue that segregation no longer exists. It didn't need to prove equality had been secured for the future. It only needed to redefine the standard. No disputes became the new benchmark. Not equity, not outcomes, not protection against regression. And once that standard is accepted, the system begins to unwind itself. We've already seen the pattern. The lifting of a decree in Plaquemines Parish, the removal of language banning federal contractors from operating segregated facilities, each step small, each one framed as technical, overdue, procedural, but together they form a coherent strategy. Roll back enforcement first and let consequences surface later. This is how civil rights erode in practice. Not through dramatic reversals, but through the quiet withdrawal of oversight. And when that withdrawal collides with lived reality, the effects are no longer abstract. They land on real people in real classrooms. That collision is the next turning point. The second rupture doesn't arrive in a courtroom. It arrives on the ground. Because when oversight disappears, patterns don't wait for permission to return. They reemerge through zoning lines, resource allocation, staffing decisions, choices that appear neutral but rarely are. The Trump administration offered no evidence that the crisis of school segregation has been solved. Not in DeSoto Parish, not in Plaquemines Parish, not anywhere else where these decrees are being dismantled. That absence is telling. Civil rights activists and parents have already warned what follows when enforcement retreats. Segregation doesn't announce itself as defiance anymore. It presents itself as inevitability. Schools become separate, again, not by law, but by consequence. And once that separation hardens, reversing it becomes politically toxic and legally difficult. This is the danger of acting as if the future will automatically improve simply because the past was confronted. Progress is not self-sustaining. It requires maintenance. When government abandons that role, the burden shifts downward onto families, communities, and children who never consented to becoming test cases for ideological experiments. And that's where this story stops being theoretical. Because now it reaches you. If you're listening to this, it's tempting to think this is someone else's problem. Another parish, another courtroom, another line item in a Justice Department memo. But imagine this through the lens of a parent, or a student, or simply a citizen who believed certain battles had been settled. When federal oversight disappears, it's not abstract principles that absorb the shock. It's classrooms that quietly diverge. Resources that thin out in some schools and concentrate in others, opportunities that narrow without ever being formally denied, and you're told this is normal, that nothing is technically wrong. That's how inequality now operates, not with signs and laws, but with silence. If this makes you uncomfortable, it should, because desegregation decrees were never about punishing the past. They were about protecting the future. If you care about what kind of country hands fewer protections to the next generation than it inherited, this is the moment to stay engaged. To question the stories power tells when it retreats. Because once vigilance is outsourced to no disputes, the people most affected are the least equipped to fight back. And this isn't contained within Louisiana. The ripple effects don't stop at parish lines. They move outward. What begins in one state rarely stays there. As the Associated Press reported, The Justice Department's efforts in Louisiana are part of a broader national push to unwind school desegregation cases across the country. This is not a local experiment. It's a template. When federal authority signals that enforcement is optional, other jurisdictions take note. They don't need instructions. They read incentives. A lifted decree in DeSoto Parish becomes a precedent. A dismissed case in Plaquemines Parish becomes reassurance. And slowly, a nationwide system of deterrence built over decades loses its teeth. This has geopolitical consequences too. America has long presented itself as a country capable of self-correction. Civil rights enforcement was proof that the system could confront its own failures. When that enforcement is rolled back, the message changes. Domestically, it tells communities that protection is temporary. Internationally, it weakens the moral authority the United States claims when it speaks about equality, democracy, and human rights. Power, after all, is not just military or economic. It's credibility. And when credibility erodes, so does the ability to lead by example. Which brings us to the hardest question of all, not what's happening now, but where this path leads next. When systems retreat, the future rarely moves in a straight line. It branches. From where we stand now, three paths are visible. The first is the most optimistic. Courts, communities, and civil society push back. Civil rights activists and parents succeed in forcing renewed scrutiny. Segregation is named when it reappears, and new safeguards different in form but similar in purpose are built to replace what was lost. Progress survives, but only through friction. The second path is quieter. Decrees continue to disappear. Nothing dramatic happens at first. No headline crisis, just gradual separation that becomes normalized. By the time the effects are undeniable, they are described as irreversible facts rather than political choices. The third path is the most dangerous. The rollback accelerates. Enforcement vanishes faster than resistance can organize. Segregation returns not as policy, but as structure embedded, defended, and eventually denied. History suggests systems tend toward the path of least resistance unless deliberately redirected. The question, then, is not which future is possible, it's which one is chosen. And that choice, whether acknowledged or not, brings us to a final reckoning. For a long time, America believed it could solve racism by declaring it over, but history has never worked that way. Desegregation, consent decrees were not relics. They were reminders, proof that progress requires presence, not just principle. What we're witnessing now is not simply the end of old cases. It's a test of memory, a test of whether a society understands why protections existed before deciding it no longer needs them. The Trump administration did not present evidence that segregation has been defeated. It chose instead to assume the future would behave better than the past. That assumption has consequences. If this analysis resonated with you, stay with this conversation. Share it. Question the narratives that frame retreat as resolution. Because civil rights don't usually collapse in a single moment. They erode when vigilance is dismissed as unnecessary. And the most dangerous phrase in any democracy is not hatred. It's nothing seems wrong. If you want to understand where this path leads and how history responds when safeguards vanish, there's more to unpack next.